provided to the jury at the end of next week. Is that correct?
Yes, sir. I can say that I will have 2 days of rebuttal. I can't control when I get to rebuttal, but
I completely understand that. I'm doing my best to skip, because see, I'm about to make a decision whether I grant the request to not convene this court tomorrow and to come back for only part of a day on Friday. And I've told the jury that they should expect 2 weeks, and I'm trying just to get a gauge. I'm not going to hold you to anything precise. It's going to take the time it takes, but I want to be fair to everyone and make sure I'm making the right decision.
it's still our intent and our plan for that to occur.
Okay.
Which we've spoken about frequently. Yes.
All right, and this is the schedule you wish to proceed on as well?
Judge, I'd like to go right into it, although I cannot object because I cannot complain of prejudice on the schedule proposed by defense counsel. It's not the schedule of my choice, but it's the schedule I will agree to.
All right, okay. Bottom line is that it's fair to say your case is concluding a little bit sooner than may have been initially predicted, correct?
Not by my prediction.
I'm getting this feeling I'm not going to get an answer.
No, Judge, I knew how long my case was going to be. How they anticipated my case, I can't speak to. I thought that I would be closing it on Wednesday.
Okay, all right, okay. All right, well look, I understand that you've got a number of experts, that you've made some arrangements for them, that you did your best to predict the time frame. I don't think it's unreasonable, and apparently without objection or without strenuous objection, I'm going to grant the defense request for that time so you can be adequately prepared and we can make sure all of our witnesses are here and ready to go. Now, in agreeing to that, we are going to do exactly that, be adequately prepared and have everybody here and ready to go, okay?
Everyone will be ready, Judge.
All right. I'll bring this jury in on the request of counsel. I'll present to them the stipulation with instruction. I'll then send them home to return here 8:30 Friday morning. That's what you wish?
That's fine.
And that's what you'll accept?
Yes, sir.
Okay. That's correct. All right. Anything else before I do exactly that?
At some point, whether it's before or after we formally adjourn, I'd like to bring up a matter that involves a public records request for the transcripts of the confession, which previously were subject of a court order exempting them from disclosure. And I will not act, and our office will not act without acquiescence or order of this court to allow us to give them the prior court order.
Well, you're going to get a chance to address any matters you wish right after I send, unless you believe it's something I need to have the jury here for. I plan to bring them in and go ahead and be considered their time and send them home. And then you can raise that as well as any other issues that we need to now. Are we going to have matters that we need to address that we're not going to address today that we need to address first thing Friday morning? Because I don't want to bring these people here and have them just sit.
Judge, we're ready to go forward with the JOA argument today. If you wanted to do it today, otherwise we could convene earlier on Friday, whatever the court's pleasure.
No, prepared to do that today if you are, and if the state is.
Yes, sir.
Okay, and we can address that. Okay. Anything else before we bring this jury in?
No, sir.
Bring them in. That's just be seated. All right, we're ready to proceed. Counsel?
Yes, sir.
You wish the stipulation between the parties to be presented now? We do. With that, members of the jury, the state and defense have agreed to certain facts. You must accept these facts as true. With that, I'm going to read to you a stipulation regarding identity. It is hereby stipulated by and between the state of Florida and the defendant, Julie Schenecker, that Bo Schenecker and Kalik Schenecker, the persons named in the indictment in this case, died on January 27, 2011 in Hillsborough County, Florida. We hereby certify the foregoing stipulation is made in good faith and for the reasons herein alleged. It's dated the 7th day of May, 2014, signed by the defendant, Julie Schenecker, counsel for Ms. Schenecker, Jennifer Spradley, and counsel for the state, Mr. Jay Pruner and Stephen Nagawa. So, with that, we'll now turn to the state. Call your next witness.
State of Florida, arrest, Your Honor.
All right. Thank you, counsel.
Yes, sir.
Now, members of the jury, with that state having rested its case, we're going to be concluding for the day. And you recall at the outset of these proceedings, I told you that we're going to do everything we can, and trust me, we're doing our best in that regard to be considerate of your time. But I told you we would also be dealing with a variety of matters as we go along. So I do my best to be considerate of that time and fashion an appropriate schedule that's considerate of you and the many things that the counsel and the court have to do. We're going to be coming back Friday morning at 8:30, not tomorrow. So you're here on the 7th, Wednesday. You'll return on Friday, the 9th of May at 8:30 a.m. And we'll come back. Back, we know, means straight to courtroom 53A. So that means you will not be here tomorrow, but you'll be back Friday morning at 8:30. Now, I'd ask all the same requests that I've made in the past, and that is, one, you give yourself plenty of time Friday morning so we can get that prompt start. Number two, that you get plenty of rest tomorrow evening so that you can be completely alert and attentive as we go about these important proceedings. You know that as I send you home for this little bit longer than usual recess, I'm going to remind you of those very important instructions. We're in the course of trial. You're instructed not to discuss this case among yourselves, not to discuss it with anyone else, not to allow anyone to discuss it with you. If anyone attempts to say anything to you or in your presence about this case, you tell them you're on the jury trying the case, tell them to stop. That person persists. Again, you leave them at once. The very next opportunity, you're going to tell one of the bailiffs who in turn will advise me. I'll remind you this case must be tried based upon the evidence presented in this courtroom, in your presence, in the presence of the attorneys, the defendant, and the judge. You're not to conduct any investigation on your own. You're not to visit any of the places that may have been described in the evidence, not to read nor listen to any reports about the case from any source whatsoever, not to speak at all with the attorneys, the witnesses, or the defendant about any subject until your deliberations are finished, and not to do any sort of research, gather information about, or communicate about the case or the people or places involved through any means, including all those different electronic devices out there. With those important instructions, our schedule's set for Friday morning. We'll see you then.
All right.
Execs in the courtroom, everyone can be seated. I'm going to hand the stipulation to the clerk. And now, I can hear from counsel. Yes.
Good evening, Judge Davis, and on behalf of the defense, at this time I would renew all previously filed motions in this case, specifically to include the motion to suppress Ms. Schenecker's confession and all motions in limine filed. I also move for a judgment of acquittal at this time. Viewing the evidence in a light most favorable to the state, the defense's position is that the state of Florida has not proven a prima facie case of murder in the first degree. Judge, in order to prove murder in the first degree, the state must prove the following three elements. As to both counts, we would agree that there is no doubt, based upon our stipulation, that both Bo and Calix Schenecker are deceased. The state has proven a prima facie case, at least, that Ms. Schenecker is the one that did the act causing the death. However, it is our position that the state has not made a prima facie case as to element 3, that there was a premeditated killing of either Bo or Calix Schenecker. And at this time, we would respectfully request the court to either dismiss the charges, or in the alternative, we would ask that you would reduce counts 1 and counts 2 to either second-degree murder or manslaughter. The law in the state of Florida is well settled that in order to prove premeditation, the state has to prove more than an intent to kill. Judge, I'm specifically referring to the definition of premeditation to Miller versus State. That's 770 Southern 2nd 1144. It's a Supreme Court Florida case. I do have a copy of it for Your Honor if you need it for your reference.
You can certainly hand up anything, as long as you hand it also to your colleague on the other side.
Oh, yes, sir. You sure?
Go ahead.
Judge, I believe I was at the point where I was reciting the definitions for you, that the state has to prove more than an intent to kill. Rather, they have to show a fully formed conscious purpose to kill, formed with sufficient time to permit reflection as to the nature of the act and to the probable result of the act. Much of the evidence that we've heard over the last few days, if not all of it, in regards to the theory of premeditation, comes in the form of Ms. Schenecker's statements, her journal, and the recorded interview. This evidence shows that the defendant did not commit premeditated murder because she did not form the conscious purpose to kill. The decision to kill was not in her mind at the time of the killing. We were introduced to her journal that was read through crime scene technician Matthew Evans over the last few days. And specifically in the journal, Ms. Schenecker makes numerous mentions of putting the children to bed, making them comfortable. She cites, I believe I have saved them from pain. And finishes the journal entry with the statement, "We're going home today, take us home, Lord." In her recorded statement, you hear her asking, "Are my kids coming in later? Are you leaving my kids where they lay? I just toppled over, the last straw. I knew we were coming to suicide. I wrote a really long suicide note. I sure as hell would like to go third." And our position is that those statements showing our evidence of the fact that she didn't know that the children were deceased. In fact, at one point she states during her recorded interview that she doesn't know whether the children are deceased or not. The statements amount to evidence that Ms. Schenecker had no intent to kill, did not sufficiently reflect as to the possible result of her action. What this evidence shows is at the time of the killing, Ms. Schenecker did something imminently dangerous to another and demonstrated a depraved mind. Murder in the second degree defines an act as imminently dangerous to another and demonstrating a depraved mind is that if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself indicates an indifference to human life. We would argue that jury instruction that the definition of murder in the second degree fits the facts of this case more closely. Murder in the second degree, the state does not have to prove a formed intent. The facts also fit more closely to manslaughter, where the state would only have to prove death was because of an act intentionally committed by a defendant, and that act caused death. The evidence presented by the state in the form of Ms. Schenecker's own words clearly shows that she had no conscious purpose to kill. I am aware that the law in the state of Florida allows for premeditation to be proven by the defendant's statement, but I would urge the court to be critical of the statements that are in evidence. The state of Florida presented to the court, to the jury, a recorded interview, and also the jury was able to see video evidence of how Ms. Schenecker looked right after the interview was given. Throughout the recorded interview, we learned that Ms. Schenecker had ingested prescription pills, alcohol, and all of this was done in an effort to commit suicide. There's evidence that she had repeatedly fallen asleep. You can hear her shaking and spilling things. And a careful listen of the audio would show that the detectives that were interviewing her were essentially feeding Ms. Schenecker the details that they'd known, while she is essentially just agreeing, mainly just agreeing with them with what they're saying. I suspect that the state will rely on the act of purchasing and then picking up the gun in support of premeditation. However, if this is viewed in conjunction with the other evidence that I've just mentioned to you, the statements that we've heard throughout this trial, that fact simply shows Ms. Schenecker's strong desire to commit suicide. The evidence presented by the state doesn't exclude every reasonable hypothesis that the homicide occurred in a way other than by a premeditated design. My position is that a verdict of first-degree murder could not be sustained. Because the purchase of the gun could have been for the sole purpose of carrying out a suicidal ideation, the state's evidence does not exclude every hypothesis that there was no premeditation. And because premeditation is one of the essential elements which distinguishes first-degree murder from second-degree murder, and the state's evidence does not show a prima facie case of this, the defense at this time would be asking for dismissal or any alternative reduction of counts 1 and 2 of the indictment. I apologize, I think I said information earlier.
Okay. All right. I'm going to be returning to the state. I will ask you, you've given me Miller. What is the standard for the court at this stage of the proceedings, and how may premeditation be proven or inferred?
Judges, I'm sorry, are you asking the prima facie case standard?
I'm asking you at this stage of the proceedings, and how it may be proven or inferred.
Judge, if I may respond to the Miller case, I simply provided that case to the court for the definition of premeditation, not for any of the other rulings or holdings in the case. It's simply the standard definition that the Florida Supreme Court uses for premeditation. It was just a reference point.
Okay. Thank you. State.
Your Honor, first I would say that there is direct and circumstantial evidence establishing premeditation. The direct evidence is comprised of, among other things, her statements that she wrote out in her handwriting in the journal. Because it rests on direct and circumstantial evidence, then the court's analysis is not to be whether or not the evidence excludes every reasonable hypothesis of innocence, because that is the standard to apply only when the state's case rests entirely on circumstantial evidence. In that direct evidence, the written pronouncement of her intent, Ms. Schenecker wrote after an entry of SUN, which I suggest a reasonable inference is stood for Sunday. She bemoans the fact that she could not bring the gun home on the date she purchased it and wrote, "I did all my duties and I went to buy a gun. I was planning on a Saturday massacre, but I have to wait on the background check for 3 days. I'll go back up to pick the Smith & Wesson up on Thursday." And that's exactly what happened. That is a direct pronouncement of what she ultimately did, which was to conduct and perform a massacre on Thursday when she first put her hands on the gun. You can also look at the manner of the deaths involving the use of a deadly weapon and the location of the wounds. Single shots to the side of the head, then followed up by subsequent shots to the mouth. There are additional writings in that book, Journal States Exhibit 33, before the murder, where she indicates Calyx, she gets it first. And then she writes on an entry after the letters TUE, which I suggest stands for Tuesday. Calyx was so shitty yesterday when she said women wear makeup and dress up tomorrow for the mandatory meeting. She called me pathetic on Saturday. She called me an evil soul. And in parentheses she wrote, "The evil starts Thursday." Judge, those are two direct pronouncements of her state of mind to conduct or perform a premeditated murder. The whole circumstances surrounding the intent to her statements, and then her oral statement in her confession where she says and acknowledges that she has been planning this for a long time within the context of the discussion of the killing of the children. I suggest that there's not only a prima facie case, but there's at this juncture it's been proved to a standard much higher than the prima facie case of guilt. I would ask you to deny the motion.
Anything you wish to add, Counsel?
No, sir.
All right, thank you. I've presided over this case, listened very carefully to the evidence, listened to the motion of counsel for Ms. Schenecker and the argument from the defense and from the state. I'm familiar with Miller. Probably want to read the entire opinion. And accordingly, the court is going to deny the motion for judgment of acquittal as to count 1. We'll also deny the motion for judgment of acquittal as to count 2, finding that there's competent, substantial evidence to go forward. To the extent you've renewed all prior motions and objections, including the defense motion to suppress the defendant's statement, those prior rulings will stand, and that's noted for the record. Okay? We've addressed that. Other matters now, I think you, the state, had something you wish to address?
Yes, sir. I've been advised by way of email that our office has received a public records request for copies of the transcript of the defendant's interview that was published in open court today. The contents of that interview, whether it be reduced to compact disc form or transcript, was the subject of a prior court order by the predecessor judge in this case, excluding that from disclosure pursuant to the public records. It is, given the prior court order, it is the state's intent to await direction from this court to allow release, so that we are not in contempt of the prior court order.
Okay. Well, let's talk about that for a second. Do I understand that now, with the publication here in court, that the entirety of that statement has been made public? Is that correct?
With the exception of the one redacted portion that was redacted by agreement with counsel.
There is the one portion that was redacted.
Right, I saw that in the transcript. Can you show me the content of that?
Yes, I can.
I can go back and get my copy and...
yes, sir. I think I have a full, clean copy without redactions. You know what page we're on, Jim? 60. Here it is, yes.
We approached?
Yes.
clear.
I've spoken with counsel. What we have is we have the transcript and I believe the audio of the recorded interview of Julie Schenecker. Previously, if I understand correctly, that recorded interview and the transcript that was created attendant to that was the subject of a motion and essentially a protective order. It was ordered not released by Judge Moody, correct?
Correct.
Yes, sir. Okay.
Well, portions of it, yes, Judge.
Portions of it. Now, with the exception on page 60 of the transcript, of lines 2 through 13, all of this has now been no longer a legal basis at doing an appropriate analysis to withhold that from release when properly requested. And I'm going to make that clear. So to the extent that there's a prior order that would require that it not be released, that is no longer in effect. On counsel's request, that portion that has not been released, that has been redacted while we're in the pendency of trial, is not to be released. That's those lines I indicated on page 60. Is that clear enough? Or do we need any clarification there?
I understand completely, Judge.
Okay.
Yes, Judge.
All right. Okay. Let me hand this back to you, sir. I believe that's yours.
Yes. Yeah.
Okay. Other matters that we need to address today?
Nothing from the state.
Judge, I was just wondering for scheduling purposes if the court would be inclined on Friday to do a preliminary run-through of the jury instructions, if the court was okay with that.
Absolutely. I've reviewed what you presented. I expect counsel in the usual fashion to have gone through that together, to have agreed where you can agree, point out where you're going to disagree, put a sharp point on it so we can make decisions and be prepared with the law to address that. I have at least one special instruction that's been requested, so certainly we can do that as long as you are prepared to do that on Friday.
Yes, sir.
Okay. Now, also, there'll come a point in the defense case, counsel, there'll come a point in the defense case where I'll have to have what's commonly called the trial colloquy, a discussion with Ms. Schenecker concerning her Fifth Amendment rights. You're going to let me know when you're prepared and wish to do that.
Yes, Your Honor.
Okay? Other matters before we adjourn?
Nothing from the state.
Nothing from the district.
All right, thank you. We'll see you Friday morning.